Hello everyone, I am Clarice Diaz and today I will be going over competence to plead guilty. What is competence to plead guilty? According to the textbook, competence to plead guilty is a plea that is knowing, voluntary, and intelligent. Moreover, more than 90% of all criminal cases are resolved through a guilty plea rather than through a verdict reached after a trial. Three aspects of understanding according to the Supreme Court. The defendant must know these three criminal processes, starting off with 1. The nature of the charge pled to. 2. The penalties associated with the charge. And 3. The rights waived by the plea of guilt, which include the right to remain silent, the right to confront one's accusers, and the right to a jury trial, as well as the right to a counsel. Competence to plead guilty continued. The determination must be made by a judge only, on the record, at a plea hearing, which is also often called an arraignment. Usually, this is a short process that consists of series of questions which are directed at the defendant, who usually answers in monosyllables, as directed by a defense attorney. I have also added the media links to both of these cases, just in case if anybody wanted to read them in their entirety. Important cases that help shape what competence to plead guilty is today. The first case we have here is Sealing versus Amen, 1973. The problem here was, does a person who pleaded guilty have to be more competent than a person who chooses to stand trial? The case summary was, Gilbert F. Sealing was charged with 3 counts of assault with a deadly weapon and 5 counts of assault to commit murder. At his arraignment, the court entered a plea of not guilty for him and granted a defense motion for the appointment of 2 psychiatrists to examine him to determine whether he was competent to stand trial. The solution was, in Sealing versus Amen, the court held that a person is incompetent to plead guilty if a mental illness has substantially impaired his ability to make a reasoned choice among the alternatives presented to him and to understand the nature of the consequences of his plea. Moving on, in 1993, the case of Godinez versus Moran had a problem that, does the Due Process Clause of the 14th Amendment require a trial court to apply a heightened reasoned choice standard to determine the competency of a defendant to enter a plea of guilty or waive counsel? The case summary was, Richard Allen Moran pleaded not guilty to first-degree murder. The court then assigned him to 2 psychiatrists which found him competent to stand trial. Thus, Moran then requested to dismiss his legal counsel and change his plea to guilty. This is because Moran wanted to prevent anyone from introducing any favorable evidence. The solution was, in the Godinez versus Moran, the United States Supreme Court rejected the previous standard in Sealing versus Amen, holding with most federal courts that a person who is competent to stand trial is also competent to plead guilty. The main reason that the court gave this decision was that, contrary to the insinuation in Sealing, a person who stands trial, like a person who pleads guilty, must also be able to decide whether to remain silent, confront accusers, and waive the right to a jury trial. An instrument that was developed to help with this objective in mind was called the MacArthur Competence Assessment Tool Criminal Adjudication. This is an instrument that was developed to examine the reasons for a guilty plea, and it tries to differentiate between rational and irrational ones. For example, I'm pleading guilty because I signed a confession versus I'm pleading guilty because I'm the worst sinner in the world. Another definition of this instrument is it is a clinical instrument which is used in assessments of adult criminal defendants' competence to proceed to adjudication. Thus, it is worth emphasizing that to ensure that defendants are competent in the appropriate areas, all defendants should be questioned about their understanding of the rights they waive when they are trying to make a guilty plea. Here are some questions about competence to plead guilty based off of this video. First one is, what are the 3 Supreme Court aspects of understanding? Explain. In your own words, what does competence to plead guilty mean? What percentage of criminal cases are resolved through the guilty plea instead of a final verdict at a criminal trial? After going over both cases mentioned in this video, which one is more rational in their opinion, and why? What instrument was created to examine reasons for a guilty plea between rational or irrational? Please explain. A case about competence to plead guilty is about Michelle Blair, a 35-year-old woman who murdered her 2 children and stuffed them into freezers for 3 years. In her defense, she stated she killed her 2 children for sexually assaulting her youngest son, as well as stating that they were demons. Blair also stated various times in court that she is guilty, but the judge at her competency arraignment explained that because a second psychiatrist did not turn in the paperwork on time, meant that he, the judge, could not make a decision at that time. In this media link is about police detectives in 1987 who used flimsy evidence to pin a burglary, rape, and murder case on James Thompson and James Owen, who were both sentenced to life in prison. Fortunately, 20 years later, DNA evidence cleared their names of the rape and unraveled the state's theory of the crime. But instead of clearing the names or exonerating these 2 men, prosecutors pushed them to plead guilty to the crime in exchange for freedom. What the prosecutors offered was a controversial deal called an Alford plea. While the book does not mention an Alford plea, this is a type of guilty plea in which the defendant does not admit to committing the crime but agrees that the prosecution has enough evidence to obtain a conviction. I thought this would be interesting to also link, so I highly recommend for anyone interested to watch the video. This next media link is about an article called Competency Evaluation, again ordered for mentally ill man charged in spree killing. Miles, also known as a spree killer, was charged in 4 killings. He was also mentally ill. He refused to plead guilty in front of a judge and is going to be evaluated for mental competency. According to court documents, Miles has already been evaluated at least 8 times for competency. Miles has been diagnosed with schizophrenia, but according to documents, when he is medicated, he is mentally competent. I thought this article was interesting to see and to learn about somebody who is or has mental disorders diagnosed. Thank you. I hope you all enjoyed my video on competency to plead guilty. Have a good rest of your day.